Good morning, good afternoon, and good evening to everybody, depending on when and where you are watching me from. Welcome back to my YouTube channel. I am Zinga Hudson. I will be a legal advisor for today. And today, one of the issues or legal issues that I would like us to dive into is matters concerning arrest as per Cameroonian laws. So, under Cameroonian law, matters of arrest are principally governed by the Cameroon Criminal Procedure Code, the Cameroon Constitution, and the relevant international instruments ratified by Cameroon. So, all of these laws will all be analyzed below as per matters of arrest. So, stay tuned and don't touch that dial. Alright, so without any further ado, let's get straight into it. We are going to kick off first from the constitutional point of view and its ideologies as per matters of arrest. Article 65 of the Cameroonian Constitution incorporates the preamble as part and parcel of the Constitution. The preamble as per matters of arrest provides that no person is to be prosecuted, arrested, or detained except in cases and according to the procedures laid down by law. The preamble also goes further to state that every accused person is presumed innocent until proven guilty. The legal effect that this has on a trial or on a suspect is simply to the effect that any person arrested outside the provisions of the law, specifically the Cameroonian the CPC, is then considered or can be considered as being arrested illegally. So, yeah. The next issue we are going to look at, which is also of importance, is who has the power to arrest, as in who can arrest you. Article 30 of the Criminal Procedure Code gives the power to the judicial police officer, or in short the JPO, to carry out investigations and to arrest suspects. The judicial police officer here are persons, law enforcers. For example, you have the state council can be a judicial police officer, officer of the legal department can be a judicial police officer, police officers are also judicial police officer, and also gendarmes. Gendarmes can also be considered as judicial police officers, where they are legally empowered to carry out such acts. Okay, so the next issues I would like us to talk on is types of arrests which are being permitted under the Cameroonian Penal Code, under the Criminal Procedure Code, as per matters of arrest. One of which you have a flagrante delicto arrest. Flagrante delicto simply refers to a situation in which a person is caught while committing the act, when he has committed the act, when he is being chased by public outcry. That means when the person has stolen something or done something and the public is pursuing him. And lastly, when a person is being caught in possession of items which are linked to a crime scene. Now, it is important to note that in cases of flagrante delicto offenses, you can be arrested without a warrant of arrest, and it will be lawful. However, the only stems a problem when the relevant provisions of the flagrante delicto offense has not been followed stricto sensu, and the person has been arrested. Hence, you can declare that arrest an unlawful arrest. Provisions of the law which guide flagrante delicto offenses runs from section 103 of the Criminal Procedure Code to section 107 of same. So next time you are arrested in a flagrante delicto offense, you should know better than to ask for a warrant of arrest. Arrest warrant. An arrest warrant is mostly looked upon in sections 25, 26, and 154 of the Criminal Procedure Code. An arrest warrant must be in writing. It must be signed by a competent judicial authority like an examining magistrate, and it must specify to whom it is being issued to. Legal advice here in this situation is that if in case you are being arrested, always request to seek or to see the arrest warrant. If no arrest warrant is being provided by the said persons or said person, then such arrest can be questionable or challengeable, depending if the case is not a flagrant delictive offense. The next issue I would like us to dive into when it comes to this legal aspect of arrest is police custody. Now, it's important to know that police custody or detention usually comes after your arrest. You cannot just appear in custody. That would be crazy. So, yeah, police custody is governed by sections 119 of the Criminal Procedure Code. And specifically, we are going to be dwelling on its time frame. So you are supposed to be detained once, which is 48 hours, but may be renewable. The first detention may be renewable again for another 48 hours term by the state council. Another instances in which you are detained or you are staying in police custody may be extended is in matters of state security and terrorism. If you are a threat to the state and a terrorist may be kept in police custody for way longer. It is important to know that overall, the main time frame or the maximum time frame of which you can be in police custody is 96 hours. After which you must be released immediately or you are brought before the state council, failure of which makes the whole detention illegal, and as such you can take legal actions against such person for infringing your rights, right to a lawyer or your right to a counsel. This is strictly governed by section 118 sub 1 of the Criminal Procedure Code, which stipulates, and I state, a suspect has the right to be assisted by a counsel during preliminary investigations, and if denied access to the lawyer, he may render the statement inadmissible on grounds of nullity. The issue I would like us to dive into today is the issue of bail and release. Bail is governed stricto sensu by sections 246 of the Criminal Procedure Code, where it stipulates that bail will be granted by the examining magistrate, meaning that the examining magistrate can't grant bail where the offense is not too serious and where the suspect has guaranteed that whenever he is needed, he will appear. As per concerning the said case, police bail may also be granted in minor cases, meaning depending on the severity of your case, you may or may not be granted bail. Some as not all offenses are bailable offenses, just depending. The case of illegal arrest, what you do and the remedies available for you. Now, this is governed by sections 184 of the Criminal Procedure Code, and it suggests in a kind of a way, it suggests that you can bring an action against the state for wrongful detention, for wrongfully locking you up, meaning that you have been arrested illegally. As per all we have been saying this while, you can bring an action against the state and make your claims and state your claims. Another remedy available to you is that you can apply for a habeas corpus. If you don't know what that is, you can just quickly look it up. Last but not the least, another remedy available for you is that's if the matter is before a court, you can raise the objection of illegal detention before a competent court, and if you have a smart lawyer, he can follow the procedure to make claims. Brings us to our last and final chapter for today. But before that, I would like us to remember a few things when you are under arrest or when you are being arrested. Number one is always to stay calm and ask, am I under arrest and for what offense? After the answer has been given to that, you ask for an arrest warrant if not flagrantly deadly to offense. Request for a lawyer or to see your lawyer immediately. Do not sign any paper without understanding it. Last but not the least, ensure that your arrest does not exceed 48 hours plus 48 hours if instructed by the state council. Aside from the confines of this, it makes your arrest illegal, and as such, you may make claims as earlier stated above. So, thank you very much for watching, and give a suggestion on the next legal advice video you would want to see. I'll be open and be reading the comments. Thank you very much, and have a blessed day. Out.